Good morning, good afternoon, everyone. Welcome to the Masterclass, the legal risk map for the AI era founders. We are going to be talking about the 15 legal risk most companies discover it's too late with Sulba Sankela. I want to start by saying this. You are not here by accident. You are here because you are the builders, the leaders, and decision makers in a moment where business and AI are reshaping everything. It's about how we build, how we secure, and how we scale. And today you're actually stepping into the room designed not just for learning, but for access, acceleration, and action. For those of you who I have not met, I'm Chaitra Vidulapalli. I'm the president and co-founder for Women in Cloud, and also recently joined the board of World Trade Center in Washington. And my life's work is simple: design systems that unlock access at scale. Not one opportunity at a time, but entire economic pathways for people to grow, earn, and lead. So before we dive in, let's make this interactive because the best rooms are not the one where people just listen. They're the ones where people are thinking, reflecting, and engaging. I want to get a quick sense of who's here in the room. So Carolina, if you can move the slides, is which best describes your role? Put it in the chat for me. Are you a founder, a senior executive, a technical leader, professional and individual contributor, an investor or an ecosystem builder, or a student? Founder and chief architect. Go ahead, put it in the chat. Okay, I'm glad we are going to have more of us really start to engage. And I don't know why some others are not putting in the text. So go ahead and put it in the chat. The second question I want to ask each one of you is, which legal risk keeps you up in the night or up at night? Is it a data privacy breach, AI hallucination, employee misuse of AI, which really results into getting fired, right? And then copyright and IP lawsuits, government regulation, customer contracts, or I slept great and assume legal will handle it. Which one are you thinking about? What keeps you up in the night? I can tell you, as a founder and a president, I believe all of that works for me. I'm always thinking about what's happening. How do we need to think about from a legal point of view? What about for you? Put it in the chat. Is it 1, 2, 3, 4, 5, and 6? The more interactive we are, the more we will learn today. And legal is one of those topics where you want to be quiet. Go ahead, put it in the chat. Privacy. 3 and 4, employee misuse of AI and copyright and IP regulation. Okay, so just know that we are not all starting from the same place, and that's exactly why this conversation matters. Because legal conversation today is about moving you all from fear to hope, of creating curiosity about that topic and driving your capability as you're building your company or you're contributing to a company, and ultimately driving the ultimate accountability so you are leading at the right altitude. Because here's what we are going to explore today. We are going to talk about the 15 AI legal risks most companies discover is too late, the contract clauses that the founder should never sign without a review, how to protect your intellectual property in the AI era, privacy compliance and cybersecurity requirements, and also a 90-day plan on what does a legal risk mitigation looks like. And this is all about the contracts, the compliance and protection strategies that you need for your business. But also, so keep the answer. So here's what I would like each one of you to think about is, with all this information that we are going to share today, the goal is to help you lead with really clarity, like ultimate clarity, driving the authority and the trust, even when things are changing fast. So, quick, I think we would go to directly to what we want to talk about today is if you are an investor, an enterprise customer, or a regulator asking for your legal and AI governance documentation tomorrow, could you provide it? That's like the real question we want to address it. If the answer is not yet, you're not alone. And the goal of this session isn't fear, it's really focusing on that preparedness. And it also defines you how you lead over the next 60 days, 90 days, a year, or 5 years. So that is the goal. Janet, will there be another masterclass? I'm working right now. I don't know about this particular topic, but it will be recorded so you can watch it after the session. So, for today's conversation, it's my absolute privilege to introduce Sulbha. She's the principal attorney and owner of Nexus Law and also dual qualified attorney licensed in both United States and India. She advises individuals, startups, and small businesses on estate planning, real estate transaction, commercial and corporate matters, employability, immigration, family based law, and also around the AI governance, and provides the trusted outside general counsel support. And also with practical business focused approach, she helps her clients navigate complex legal challenges while building a strong foundation for growth and long-term success. And Sulba, I'm very excited to have you here today. And also you saying yes to supporting women in cloud community and all of us to be protected in the AI era. We are really lucky to have you.
Yeah. Thank you. Thank you for having me here. Before we start this conversation, I just wanted to ask this question in the room. How many of you use ChatGPT, Copilot, Claude, or any AI tool with company data, and how do you use it?
I do it, Sulba. I use it, but I have my own some guidelines that I put in. But if I say, am I perfect at it? That is after your session, I will come back and tell you how close I am. So, with that, I'm going to pass the baton to you and you can take it from here. And I'll join you as you need me through the masterclass.
Yeah, thank you. Thank you. My name is Silva Sankla. I'm a third generation lawyer. I saw my father litigating, my grandfather litigating. So, law was never a second thought. It was always a very honest choice for me because for me, it was common sense. It was very intuitive, and I really wanted to excel in it. With that thought, I went to London, did my master's in international business from King's College London, and then worked in India for a while, and then moved here on getting married, and did another master's in IP law from University of Washington, Seattle. All this was very systematic for me because I was getting more and more ingrained in technology, and I wanted to be sure that I have all the right tools to support myself in my growth. In between of all this, I became a mother, I ran a food business and exited it. I worked as in-house counsel for Amazon Web Services and Symmetra Life Insurance Company. I'm not telling you all this to impress you. I'm just trying to tell you that I relate to most of your experiences, which you might have had because I've had that journey as part of my experience as well. My journey for AI began when I was working with a startup in 2018 when GDPR just came in, and the startup said, okay, we need to have compliance for GDPR. And I was like, okay, what can you give me the list of softwares your team is using? And they looked at me and they were like, that's what we hired you for. And I was like, okay, so you don't even know what software your team is using. They had no data inventory, no processor agreements, no legal basis for every single piece of data which was being collected or used. There was nothing. So As part of the beginning of my AI journey, I learned how to do data mapping, processing records, consent mechanisms, and it just gave me a deep dive understanding of what GDPR was. And then I moved on to a SaaS company, and at that point, we were talking about data protection addendas. And some companies were still in the middle of figuring out whether they need to do compliance or not. And so we also came up with acknowledgements for such companies saying, okay, you acknowledge that GDPR exists and that if your data is touching any EU person, then you need to be GDPR compliant. But again, like coming from that background of structuring things from scratch, help me understand that it's not intuitive, that using of AI is intuitive. Yes, it helps you reduce time, use less effort, get more insight in small period of time. But again, it needs to have a lot of more insight built in so that you're using that data with more mindfulness and judiciousness versus just trying to create a shortcut and fuse things up because that's the fastest way for you to achieve something. I worked in an insurtech, and in that company, they were trying to automate underwriting, claims, regulatory framework, and with that came that intentional understanding that GDPR exists, that every state has its own law to make sure that there is no racial or bias, so that everybody's intentions are more towards safeguarding the individuals versus trying to process things faster and spend less time, less money. So with that journey, today I'm here, Nexus Law. We have built with the experience I had with Fortune 500 company boardrooms. I'm genuinely proud. I'm proud with this partnership with Women in Cloud because I always wanted to be a help person or somebody you can look up to when you have questions. I struggled through those questions myself by making mistakes, by doing research, by getting counseling from a lot of people. And now when I have all those answers, I wanted to be there as your attorney on call or a person you can partner with and help mitigate those problems. And I'm so thankful to Chaitra. When we had this discussion, we shared that vision that this partnership should not just be a workshop or a legal checklist which people can just take and be done. We want to be your continuous support, your first legal defense, your in house counsel, so that you have the protection you deserve, you have the representation you deserve, which most of you at the very basic steps think you don't need. But if you have that approachability, it makes that whole thought, that whole endeavor more meaningful. So I'm very thankful for Chaitra for creating this collaboration, and I look forward to interacting with you in the future individually whenever we get chance. Next slide, please. So, why does it matter? Why does it matter that we think about AI and how the law is working? 65% of startups don't have proper legal documentation, and this is found out during the due diligence phase. It's too late. A lot of times, the investors are trying to find flaws because they want to reduce the valuation. They want to pay you less and get more. You don't want to give them that chance. A legal compliance check audit would not take more than 2 to 10 hours max, but valuation will go down in hundreds, if not millions, of $1,000. Second thing which we have seen more often is average cost of miscalculation in back taxes and penalties. That's when there are operational risk or compliance risk or places where you might have misclassified how you're doing things. Now, one in every three startups have unresolved IP ownership gaps, which most of the times blocks institutional investment because they want to see the chain of IP ownership, and that would be a big red flag for them. And the final thought is that 87% of companies using AI have no formal AI usage policy, which creates a lot of hidden data and liability exposure. And most of the times, if your technology is built heavily on such tools, it's very important that there is some documentation and some ideology you're following, and it should be written and documented and followed through to make that more meaningful. We are here to talk about the five zones. Let's go to the next slide and see what those five zones are and what does they mean. There are five risk zones which my law firm looks at, and this is our classification. Every firm might have a different classification, but this is what we think should be the five zones you should be looking at. The first zone is the founder level risk, the second is the client and revenue risk, the third is the operational AI and data risk. That's where the whole AI compliance, AI policy classification comes in. The fourth is the financial and structural risk. And the fifth is the growth, exit, and investor risk. Most of the times when I'm talking to startup founders, they're like, we don't want to think about exit and investor. We are self funded and we are going to do everything ourselves. And let's not concentrate on that right now. But that's a really wrong thought. We should always think of what we will do once we excel. We should always start with this ideology, right? What we say, positive thoughts bring positive momentum. So we should always have this chalked out from the beginning to the end versus saying, oh, I'm just doing this struggle for what I should think about right now. If we are only thinking about right now, we have already lost the battle because we didn't build the blocks which could have taken us forward. We just concentrated on this small project, whereas it should have been built into a full corporation. So it's very important that whenever we are starting and whenever we are in the process, we think of all these five zones as present versus as a future endeavor. Next slide, please. So let's talk about the first zone, founder level risk. Very basic. Most of the times, the companies are starting over a cup of coffee, handshakes with friends and families, and we are like, okay, why would we have to think about shares, stocks, or founder agreements? And that's where most of the problems seed. Misaligned founder equity, no vesting agreements, undefined roles and decision rights. Let's go with an example. We are talking about a co founder dispute with 40% block. There were two founders, no vesting, one founder left after 8 months, retaining 40% of equity. New investor requires a buyout as a condition of term sheet. Now, there is a delay of 6 months and there is a valuation reduction. Why? Because within the 8 months, the company does not have a lot of revenue. And most of the time, when we are buying out equity, we need some money to pay out and give in. And that timeline, which takes for the business to earn that revenue, is crucial because, again, the investor is looking how to devalue their investment and get more equity. And you just gave them that opportunity by missing into doing that. Now, how much time would a founder agreement would have taken? 1 hour, maximum 2 hours. How much time did you lose and how much valuation you lost? Maybe thousands of dollars, right? And this is very important to think. If the founder equity has not been planned correctly, if the vesting has not been written correctly, then it's a red flag for the investor because they're like, okay, how is this going to work? Is this the standard vesting where it vests for 4 years and there's a 1 year cliff, or is it getting vested immediately? If it's getting vested immediately, it's a big risk because you're losing out that equity if any founder decides to exit, like in this example. Next slide, please. Now, the second zone is the client and revenue risk. Most of the times, we say, I asked a friend who also has a startup and they were using these agreements, and we just decided to use the same because we are doing similar, right? Weak copy paste contracts, no IP ownership clarity, and scope creep. Now, I have two examples to explain that. So let's go with the first one where we are saying, okay, the contractor owned the code. So a SaaS founder hired a freelancer developer to build the entire product over 8 months. There was no written IP assignment, just a verbal agreement and invoices which they raised and the founder paid. At the Series A, the investor council ran an IP chain of title review and they sent letter to the developer saying that you should release the IP ownership, and they said no, that was never part of the contract. It's my IP, I just created it for you and you can use it. I gave you license but you never owned it. Now that founder paid 38,000 to settle it. What could they have done? They could have made sure that they signed an agreement with them, and that part of that agreement was an IP assignment contract. That one miss cost them 38,000. How much would an attorney time have been? Not more than 2 to 4 hours. Let's go to the second example. Scope creep between becomes a lawsuit. Now, what do I mean by scope creep? Scope creep is when you hire somebody to do a particular project. The project got over and you realized, oh, there were four more things to do. And you said, you know what? Just do these four more things. We don't need to write another agreement and I'll pay you for that. Now, that additional work is a risk on both sides. It's a risk on the doer's side because what if the other company decides not to pay, right? You have no right to go and sue them because you don't have any legal agreement which puts you at that services capacity. So you lose that work and that revenue. But it can come up on the other side also, where we go back to our previous example, where if any IP was created as part of that scope creep, and say you even paid off that additional work, but again there was no IP assignment, you lose that IP. So it can go both ways. So it's very important that whenever we are doing any additional work, we emphasize on having change orders, we emphasize on having additional liabilities and IP assignment written, so that there's a very clear demarcation of what's happening, what's going on, who gets what, and what is the value of the services you're receiving. Next slide, please. Zone 3 is the operational and administration risk. Now, most of the time you're like, okay, we have a lot of contractors. And that's where the biggest problem comes in. There is a very clear demarcation of what is a contractor versus an employee. And most of the times, companies run into the misclassification juncture where an ABC test for California, or generally a litmus test for IRS, is if the person is working your hours, using your equipment, and you have the right to decide what they can and cannot do, they are not a contractor, they are an employee. So that big risk where we think, okay, not an employee, contractor, if they go off and sue you, it can lead into a lot of taxes, penalties, and interest. And this is the example which talks about same, where there was AI data labeling startup, 60 offshore workers treated as contractors for 3 years, IRS audit triggered by a former worker complaint, and they had to pay 1.8 million in taxes and penalties, and Series A collapsed. Of course it collapsed because if somebody has a 1.8 million audit or debt, then people would be very averse to that risk. Next slide, please. Zone 4 is financial and structural risks. Now, most of the times, we try to create roles and we say, oh, these are individual roles, don't want to have checks and balances on them because it becomes a lot bureaucratic. It's not about bureaucracy, it's about making sure there is segregation of duties and there is checks and balances. Because if there is no financial control, there can be tax exposure for entity misuse, and then there can also be a personal liability bleed through. Let's look into this example where a bookkeeper who wrote her own checks led to a whole Series B fallout. A 15% tech startup had one bookkeeper with full bank access, no second signatory, no approval threshold. Over 14 months, she processed 91,000 in fraudulent payments to a shell vendor she controlled. The absence of segregation of duty and monthly reconciliation reviews made it invisible. It was only discovered when the audit was held, and then they delayed it. Why they delayed it? Because whenever an investor finds one risk, they want to go deep dive because there can be more hiding. It's like you don't get benefit of doubt, right? When you create a doubt, then everything else follows through. So it's very important that whenever we are looking into these important sectors, whether it's human resource, financials, operations, we always should have additional checks and balances built in so that nobody has independent control and there is no kind of hidden agendas or people who have full control over managing things without any overarching superior. Next slide, please. The fifth and the final zone is growth, exit, and investor risk. Now, most of the times they say, oh, this is not of any importance to us right now because we are not thinking of that. But from the very first step, you can make sure that you have those small building steps built in so that you don't even have to think of it as a last step. It becomes part of your first step itself. Whenever we are building things, we should make sure we have proper cap tables. We are ready for any due diligence exercise any investor might want to do, and make sure that the IP is assigned correctly and we have written all the documentation so that if I exit today, somebody should be able to take over tomorrow without needing me, right? So the whole thing cascades through from zone 1 to zone 4, where we say if we are using any data, if we are using any IP, if we are getting any personal identifiable information, or in healthcare, if we are going HIPAA compliant information, we should always have checks and balances, roadblocks, doors, locks, and keys to make sure that only people who need that data is accessing that data, and we always know what is the source of that data and how that data is getting utilized. Now let's look at this example. There's an IP gap which kills 40 million acquisition. There was an AI image platform which was up for a 40 million acquisition, but the due diligence realized and revealed that the core model was training on 12,000 unlicensed images. Now, this is a deal breaker because you are building something on IP that you don't even own. It's a rabbit hole for a lot of IP litigation against you. And no investor, in their good sense, want to step on that rabbit hole. So it's always important that whenever you're building those things, whenever you're using AI, whenever you're using data, you always know the chain of where it originated. Do we own IP? Is it open or is it a common platform? Even if we are building on that, we should have a very clear copyright built on it. We can never assume that data is clean because if we are using GPT or Copilot, there's a lot of things which are going into background, and as we were talking initially, data hallucination and AI hallucination is real, and it can create big blunders if we do not have proper checks and balances. Next slide, please. Now let's talk about the AI layer. This layer did not exist 3 years ago. This layer is very new, and it came up with, and as it comes up, like every time we are solving something. So that means there has been lot many problems which led to creation of these rules. But it's important that when you are assessing and auditing, you know that these rules exist, and then you go back and see, okay, what is my startup doing? Are we in compliance of all those things? What do I need to take care of today? What do I need to be mindful of tomorrow? So let's talk about them in a snippet. Number one, training data copyright. Always make sure that the data which is being used is licensed, and that data, if we are getting that data from client, we are telling them that we are using their data, what is the purpose of using that data, what is anybody else, if we are revealing that data to anybody else, and what is the purpose of revealing the data, and how are we making sure that data is always protected, right? So it's always important that we take all due permissions from the stakeholders when we are utilizing their data for our own AI training. Number two, AI content infringement. AI generated text, code, or images may reproduce protected IP. Now, this is something which everybody should be aware of in this room. If they are not, this is a big problem. We are using AI heavily. AI is using World Wide Web, but that also means they are pulling all data available, and they are not declaring what data is protected, what is not protected. So when we are giving those commands, when we are setting up those protocols, it's very important that we are very clear on what we need, how we are, what our yardsticks are, what are the controls we want to put around to make sure that we do not end up into AI content infringement. Number three, customer data privacy. It goes back to everything we are talking about. Whenever we are using data, we should be very mindful of where we are putting it, who has access to it. Never put client or customer data into a free public tool. That's a big infringement layer right there. Always be sure that the data, when it is being used, it's in a controlled environment with locks and keys, that you have full control, and that you make sure that only information which is really needed is getting used to get the result you need. Now, the fourth, AI data hallucination. And what is the liability for it? Any inaccurate AI outputs create negligence and professional liability. We will talk about it in Rule 6, but it's important to say that because of this, there has been a lot of acts and regulations built all over the world to protect the customer from getting wrong or inaccurate information. The next one is employment discrimination, AI hiring, promotion, and performance tools which can create biases. Now, it's very important to understand AI is technology driven. There needs to be a human element whenever we are doing such critical work. Whenever we are hiring, promoting, doing performance reviews, we don't always look at the KPIs. We also need to make sure that we are evaluating on the basis of different scenarios which are available for different people. An example would be if somebody is on maternity leave, you cannot say, oh, there is no performance for 2 months, but the AI doesn't know, right? So you have to make sure that we are not 100% dependent on AI in doing those reviews or performance tools are used. We need to make sure there is a human element present to do those additional layers which are missing, which the AI does not have interface to. Now, I want to spend a little more time on this AI regulation and non-compliance. EU AI Act comes into force in August 2026. That's very important because they have classified your use of AI into various segments. And they say that whatever is the highest risk, now you need to make sure that you are categorizing it properly, you are making sure that the data is being evaluated, and you have all the protective layers and documentation present when before that data is given out to any customer. Similar to that, US has also come up with a regulation which imposes similar liability within US. Now, why is it important to keep track of these regulations? Is because US do a quarterly review. And if you did a review 3 months ago, you are already at risk because now you don't know what is up this quarter and whether you are still compliant with the new layer of regulation which is coming in. So, always have a quarterly review of your AI policies, of what your data retention agreements, what your terms of use, what your terms of services are, because they need to be updated as per the change in law. Ignorance of law is not an excuse. So it's always important that you have a team or a member or your preferred lawyer who's keeping you updated with those changes and you're making sure you are in compliance at all times. As the examples we looked, we talked about IP ownership confusion. Now, this confusion gets a little more broader when AI is generating work, right? When AI is creating something, who owns it? What kind of information did you feed into it? What kind of protocols, directions did you give it? Did you have more than 90% control of what output is going to come? Or did you leave big blanks with very small mission statement and somehow AI created everything for you? Now it's very important that you know what's going on and that you build that control and documentation of what you did, what actions were taken before the output was created, because you want to be owner of that IP, not the AI. Confidential information leak. Now, it pulls back to everything we were talking about: training data copyrights, customer data privacy. It's very important that employees know what can and cannot be done and what information can and cannot be given to AI. If it's a trade secret, it remains trade secret only and only when you have created those guardrails around it. If it becomes public knowledge, or if you share it with public and it becomes public knowledge, then the trade secret is lost. So it's very important that your employees do not unknowingly expose trade secrets through AI prompts. And the final one is the cybersecurity exposure. If we are using free open source tools or we are using open source tools without creating a safe, protected, closed environment, then we are putting ourselves at risk for any AI system expanded attack, prompt injection, or data breach. So it's very important that when you are using AI, it goes back to everything else we were saying, that we should have protocols, we should have AI rule book, playbooks, guidelines, so that it becomes common sense proof for your employees to how that AI needs to be regulated within your company. Now, there can be AI vendor contract gaps, and it's very important that whenever you are using a third party to process protected information, that you have data protection agreements with them and you very clearly tell them what can and cannot be done with that data. Can they use it to create commercial products, or can they use it for quality and support, or can they use it to develop, but it should be unidentifiable data. Now, again, if we don't have those protocols in place, you are giving that data for free to the vendor to do whatever they want to, and you don't want that because you have a liability towards your customer. If there's a data breach, they are going to come after you. And most of the times, the data breach reconciliation is not few thousand or few $100,000. It goes into millions, and that's one of the biggest risks I've seen companies having. So please be more mindful about that and make sure that you have policies around it. And the final one is the M&A diligence surprises, where you have training data, like the example we had that they were using 12,000 unlicensed photographs. Whenever you are doing training, you should have documentation where you can prove that you have acknowledgements from the service takers or from the customers that you can use that data for training, and that you should have governance policy which regulates how that training is being conducted, what are the parameters of that training, and what is the end result you're trying to receive. And make sure that you are very mindful of AI in general, because it is such a powerful tool, but it's such a powerful tool that it can create a lot of problems without you even getting time to think about it, because we are using AI to think and do things faster than us, but that means it can create problems for us faster as well. So please be mindful. Next slide, please. So, whenever I'm working with startups, this is the map I have. So, this is a lawyer's perspective into looking at risk and looking at things and how they are happening. So, when you are at a pre seed level, for me, the most critical things are whether you have a vesting schedule, whether you have a founder agreement, what kind of agreements do you have clear classification between employees and contractors, how are we thinking about financials, do we have proper segregation, what kind of data is getting utilized. And then that priority kind of changes when we go to seed, it changes when we go to series A, and it completely changes when we go to M&A. So it's very important that we look at this map whenever and see which stage we are at, and it helps you visualize the importance of things. And as you see, AI compliance layer is important through and through. So even if I say pre-seed, it's medium, but if your whole idea is built on AI, automatically AI compliance becomes more important than everything else. So always talk to an attorney who can support you into understanding where you are at. They can help you create a vision, they can help you create like a spreadsheet or a document where you can look at these key points and tell yourself, okay, I'm ready for this, no, I'm not ready for this, I can do this, can you help me and guide me into this. It's There is no harm in taking help. It's very important that you do the right things, because getting an attorney review your things might take 10-15 hours, but in trying to solve these things or going into litigation, it can take months and years altogether. So preparation in time, being a little more conservative and more optimum with the legal support is very important when you're building things versus when something breaks. So talk to us or talk to your trusted lawyer and look into these 15 points we have talked about and see where you are. Next slide, please. So I have a self-assessment exercise for you. So if you have your phones in hand, let's do this exercise very quickly, where for every question you can answer only yes or no. And if you say yes, you get 1 point. If you say no, you get a 0 point. If you're ready, we can start with this exercise. I am just seeing in the chat if we say it gets a lot of yes. So my 15 questions to you are: number one, do you have a signed founder agreement? equity, vesting, and IP assignment. If you have it, 1 point. If you don't, it's a 0. The next question is all founders are on 4-year vesting with 1-year cliff. Now it goes back to, do you have a vesting agreement? If you don't have a vesting agreement, then it's a big 0. But if the vesting agreement is different than this, then it's a big risk and we should talk about it. Because most of the times it takes a business 4 years to build, and you don't want to lose a lot of equity before those 4 years. The third question is founder's role and decision rights documented in writing. Does it say what a founder can do? What is the responsibility of founder number one? Is he a CEO? What is that looks like? What is the responsibility of founder number two? Is he a CTO? What that responsibility looks like? So it's very important that every founder has a role and a decision right, or would they have a veto, or if there is a majority rule, it should be written out very clearly. So if you have that, give 1. If not, that's a good point to talk about. Number 4, all client contracts include IP ownership, liability, and governing law. Now these are the basic fundamentals. If you do not have clarity on any of these 3, you need to review your agreements. Give yourself a 0. The next question, number 5, is every contractor has a signed IP assignment agreement. This is a deal breaker. If they say no, don't have that contractor. If you don't have an IP assignment agreement, give yourself a 0. The next point is all scope changes are documented. Anytime you have a work order or a statement of work, if you're changing the scope, you are doing a new statement of work or you are doing a change order. If you're not doing that, give yourself a 0. That's a big risk you have created yourself. Talk to a lawyer and see what can be done about it. The next is documented compliance calendar for all data privacy laws. Now, you need a help of a lawyer to do that because sometimes you don't even know what regulations apply. So reach out. Most of the firms already have that compliance calendar built in, so it doesn't take a lot of effort for them to build it for you. But at least have that as your target, have that understanding what is coming in, what's changing. And if the firm is on your roll, they will be able to update that compliance calendar for you on a quarterly basis so that you're always up to date. The next is number 8, every worker relationship classified using the correct legal test. The legal test we talked about was control, access, and how they are working, what they are working on, how much independence is built in. If they are deemed contractor but they are working as an employee as per the test, give yourself a 0. We need to do that reassessment. Number 9, do you have an employee handbook, data protection policy, conflicts policy in place? If not, give yourself a 0. Number 10 is financial controls. Are there any approved limits? Are there any approval records, documentation? Do you create audit trails documentation? If not, it's very important. Let's talk about it. But in the meanwhile, give yourself a 0 for this. Number 12 is business and personal finances are fully separated. There is no commingling. There is no personal money coming to your business, and you're not taking out personal checks without saying what is the purpose of that, whether it's a dividend or whether it's your income. If there is no clear demarcation of that, it's a big risk. Give yourself a 0. Number 13, cap table verified, fully diluted, reconciled against stock ledger. If you don't even have a stock ledger, give yourself a -1. No, give yourself a 0. Number 14, investor data room producibility within 48 hours. Now that's a huge thing. If you are not able to put your contracts together and give it to an investor so that they can review it and invest in you, you are non-compliant on various zones. Let's talk about it. But for now, give yourself a zero. And the last but not the least, all IP created by contractors and employees are properly assigned. If there is no assignments, even with employees, that's a big risk. Give yourself a zero. Now, let's see, as the outcome of this, where are you with the tally? I would like to see if you guys did it and what does your score come out to be. Chaitra, did you?
I started doing it, but then I got distracted. But yeah, but I think I'm somewhere in between 10 and 15. That's
Ah,
where I'm like, I'm not at a critical exposure.
okay.
And the place where I think we always have the dilemma is around the IP assignment because AI is so new. We are still in the token maxing. We don't know what IP we are actually creating in a unique way. That we don't know, right? So
Yeah.
that is something that's where you come in and you say, okay, let's look at it and see what
Yeah.
IP is there and how do we recognize all the contribution because
Yeah.
you don't want to hurt anybody. It's just the
Correct.
formally it needs to be assigned. Yeah.
Yeah, and it's just important. Again, this masterclass is not to give you any checklists only or tell you this is more of a diagnostic. This is just to help you understand where you are and tell you what things you might not even have thought about but can come back and bite you, and then start evaluating and working on it. So this is more to help you understand what you can do and what you can fix even today because you've attended this masterclass and you know what needs to be done versus finding it out once it's too late.
And it cost hundreds and hundreds of $1,000s, right?
If
And
not less, yeah, if not
yeah,
less.
yeah. Are there any other slides you're going to go? Okay.
Yeah,
Cool.
yeah. So again, the three immediate action steps are one which you should do within this week is list all the AI tools your team is using: ChatGPT, Copilot, Gemini, AI coding assistants, image generators. Note which one touches customer, employee, or confidential data. It's very crucial. You know which data is getting going where. Review your top three contractors and founder agreements. Check for IP ownership, liability cap, and governing law. Flag every gap you cannot explain to an investor. Score yourself on that 15-point audit we did and honestly tell where you're at. It would help you evaluate and it will help you come up with a plan on what needs to be fixed. Now, what is your 30-day plan? Implement a written AI acceptable use policy. Which tools are approved to be used for your teams, which is not, what data may and may not be used as input, and what requires human review before publication. It's very important that whenever and wherever a human touch is needed, you build that. It might be for 5 minutes, it might be 10 minutes, it might be 15 minutes, but build that because you want to make sure that the AI is not doing something you don't want it to do. And without checks and balances, you won't be able to understand or even become aware of that. Now, another thing which I want you to do within this next month is conduct the full 15-point legal and readiness audit with a qualified attorney. Document every gap, assign a risk level, and assign an owner on who is going to work on it and fix it. Remediate all critical items, especially IP assignments, contractor classification, and AI vendor contract data rights. Make sure that you have all these clauses in your contract if you didn't have already, and make sure that you have all the assignments documented, put together as one file, so that whenever somebody asks you, okay, where is this IP and who owns this IP, you are able to answer that. And your task for the next 90 days is to establish a basic AI governance framework. That means you have an acceptable use policy, approved vendor list, bias testing protocol, and quarterly compliance review. You build your own investor data room so that you have all the standard 12 documents, plus you have training data provenance documentation, model cards, EU AI Act capability, assessment, and that you review all your AI vendor contracts for data rights, training, opt outs, indemnification, and liability cap. The five clauses that matter the most. Let's go to the next slide. We can work on these two questions if everybody's interested. So I just want to
So,
get.
Sulba, let's pause for it. I just want
Mhm.
people to say we can do is a deeper dive session on this,
Okay.
or you can stay for 5 more minutes. You can just go through a high level. What would you
Mhm.
prefer? Because this one requires a level 2 masterclass on legal. Put it in the chat. What would you prefer? Hopefully, this one opened up your minds on how we need to think about legal and AI and business. Say yes in the chat or give me some. Okay, hold on. Level 2. Okay, so we'll do a level 2 session, Sulba, so that we can
Mhm.
come back and provide people to it. Okay.
Yeah. Yeah, so we just wanted to, as part of the masterclass, give an exclusive offer of 2 hour deep dive where we can do a structured zone by zone legal risk diagnostic, a written 2 page priority action plan within 5 business days, 1 hour of attorney prep, as well as verbal guidance on your most urgent legal risk. We can also help you with wealth planning session with a 90-minute deep dive where we talk about business succession and business legal risk and how it works for your wealth and your family. And we talk about your estate planning and family wealth goals and protection audits where we do asset tracking, portfolio risk map, and tax planning strategy. So these are the 2 offers we have for this masterclass, and we would be happy to help you if you have any of these two needs.
Silva, this one was extremely helpful, and thank you for being so generous with our community by creating offers that is affordable, accessible to
Mhm.
the legal. Because I remember going to the legal force, they'll say, we'll do pro bono, and then you realize they're on your cap table with percent of the company. And I'm like, how did that happen? You had to put them on the cap table.
Yeah.
But this one is at least you know the diagnostic and you really heard our community what they needed. There are a few questions I have, and I think if I
Mhm.
can take another 10 minutes and have the people listen, is that okay?
Yeah.
Okay, so the first question is every founder is being told to move fast with AI, but
Mhm.
every lawyer is telling them to slow down. How do companies innovate quickly without creating legal risk that could cost them millions later?
As we talked about, right, we should have a policy internally how the data is being used, what the data is being used for, where is this data coming from, and creating those guardrails. Be fast. Yeah, everybody wants to rush to things, but if we don't have the standard protocol, the standard guardrails on where is this data coming from, even if we are building it on open source, if we are creating our own code on it, or if we are writing something as a layer which should be our trade secret or a secret sauce, we need to protect it that way. We can't just build and then share and talk to people who are interested and show them everything and then say, oh, somebody stole my idea. Yes, because you did not do non NDAs, you did not do IP agreements, you did not build those structures or four walls. It's not about mistrust. It's not that you don't trust anybody. It's not about slowing you down. It's just about creating those structures to help you build. Because nobody's trying to steal your data, but it's an idea till the time you implement it 100% or bring it to public, right? Everybody can hear that idea and get inspired from that idea, right? So I'm not saying anybody is trying to be dishonest, but that is human nature. We learn from each other. And if you want to make sure that learning does not happen at your own expense, you have to make sure that you are writing it down very clearly when you're sharing that information. So the lawyers are asking you to slow down so that you have these four walls created for you before you venture into all these niceties of telling people, making LinkedIn posts and announcing this is what you're working on. Because now the whole world knows. Can you stop them from trying to use your idea to build something else. No. So the lawyers are just trying to tell you to be careful till the time you're ready to launch or you have launched. And once you have launched, you have a lot of precedence in your favor. But till the time you don't have that, till the time it's just an idea, please be careful, tread carefully, because you want to own it the time it's actually built and running.
Absolutely. I want to ask a couple of questions. One is 5 years from now, what legal risk related to AI do you believe companies will look back and say we should have paid attention to it much sooner?
I think the data dumping we are doing to AI to
Yes.
generate answers is going to come back and bite us, because people are getting more and more aware of their right to tell you to stop and their right to tell you to give back their data. But what about the data you already gave to AI? It will be misused, and once they track the source of it, they are going to come back and hurt you. And with the smaller foundations, we have lesser, or most of us might not even have cyber insurance. And those litigations are going to destroy a lot of startups even before they see the morning sun. So it's very important that whenever we are using AI, we are very strategic about it, on how we want to use it, what kind of information we are using it. At least at the very basic, have an enterprise level license with them so that they are not using your information for training their data and creating examples and saying, oh, this information. Because what if AI at one point starts telling source of data, right? Because that's what is the need of the hour, of where the source of that data is. And if that source of data is from your business because you did not take a paid license, is going to be a big explosion in litigation right there.
Absolutely. And this is the last one. I think, especially when founders are going to the investors, when investors look at a founding team, what founder agreement red flags immediately concern them? Like, how do they just look at it and say, whoa, we need to, don't even want to touch this company? What is those red flags, Silva?
I think the biggest founder red flag is the vesting. If the vesting is not conditioned strategically, then it's okay. So, what am I investing in? What if these two founders just decide to go away? 50% of the equity is just going to be gone. What is remaining in this, right? So, then that's one of the biggest red flags.
Yep.
Then the other ones is how the roles and responsibilities have been put out. Who's responsible for what? What are the responsibilities? What are the deliverables? What are the powers to each member? So they want to see the structure, right? What thought process have you built into building things? And then they want to see what kind of agreements do you have with your contractors, with your employees. What kind of remuneration are you promising them? Are you giving them equity? On the basis of what? How do they earn that equity? So they're trying to see what would be remaining in this business after 5 years, because they know that most of the startups struggle to become successful businesses for the first 5 years, because they are still building, they are still iterating, they are still learning from their mistakes and building something better. But if their equity is hollow, then it's going to be a big risk for them. The other big risk again is the IP ownership part of it. If all of the work is being outsourced and if there's just one founder, it's very important that the outsourced work is still owned by the startup, by the company. If there is ambiguity there, or if there is a misclassification kind of hinting to that, towards that, then the founders or investors are very averse of that, because they don't want to invest money and then see, oh, this money is only going towards payment of lawsuits versus utilizing into building something. So whenever they see some legal, financial, AI, or just operational risk, they step back or they reduce the valuation. to reduce their risk.
Got it. Got it. This is the last one. This is mostly around the subscription. They want to understand, confirm their understanding is the enterprise level subscription of AI tools offers some protection. What about personal subscription? Which vendor is most responsible with data? Is it OpenAI, Claude,
Nobody
Gemini?
is.
Huh?
Nobody. No, they don't even promise it. If
Exactly.
you take a personal subscription, with the personal subscription, they're just giving you advanced models. But only with enterprise level subscription are they saying we are not using your data for our AI to develop. Only enterprise level. I've used Claude, I've used ChatGPT, I used the personal and I was very wary of it. I would only give it general commands. But when it became very important for me to put more confidentiality in, I had to take enterprise subscriptions. There's no way around it.
Yeah. And again, Sulbha, this one proves every founder, because we had a lot of signups. And if you
Mhm.
look at, not many founders actually show up to the legal conversation till
Correct.
it's really
Yeah.
bad.
Yeah.
And for those who have attended, congratulations to all of you, because
Yeah.
you actually must have extended your learning and your altitude of your understanding of the impact. Yes, it will steal the data and all that, but the legal impact of that is much greater. And I want to leave each one of you, what were your takeaways from today's session? Because for me, there were like so many takeaways. I'm like writing it down. And first thing is to go and have a conversation with my team, because it opened up my mind in so many ways. So, right, it was just absolutely brilliant. So, for all of you, before we conclude, were there any key takeaways that you took today? Because this is a very deeper topic. It makes you stop and pause, and also makes you, the fear comes in because you are
Mhm.
not prepared, but
Mhm.
that's the whole point, is we want to get you prepared, and that's why the master class is the bridge between your fear and hope, and you have Sulpa on the Women in Cloud ecosystem to support you. So they like the readiness assessment, Sulpa, so that's great. What about others? Natalie, Mary? She appreciated the assessments because I realized we have agreements, some agreements in place, but there are gaps. Beautiful. If you can spot the gaps, you
Yeah.
can go take action, right? If you cannot even know that there are gaps, you're
Or
walking.
you don't even know they might be considered as gaps. Like
Exactly, exactly,
you might think
exactly,
it's standard practice. Everybody must have it because I have it. No, having this assessment helps you understand that would be a risk, or that would be considered a gap, or that's a breach, or
exactly,
that's
exactly.
how, and what it opens you up towards, right? How is it going to harm you? It's very important that at least you have that assessment and understanding, and then you look into that 90-day plan we talked about, because
Mhm.
that also helps you understand what are easy things to do which you can get done tomorrow, what
Absolutely.
might take up to a week, and then what is the biggest piece of endeavor you need to take, which you need to start now step by step, so that you can reach conclusion or completion in 90 days time.
Yeah. And Subha, one of the things which your insight on the AI layer was fantastic, because I've met with a lot of lawyers and I've spent a lot of time. You're probably the 0.001% who's talking about the AI layer at that detail, and made that one accessible for our community to know about it. We will be creating a cheat sheet with her and providing
Mhm.
you the access. And if you ever need to connect with her, she's available. She is, I would say, is in-house lawyer for Women in Cloud. So
Yeah. And
anytime you
I
need,
appreciate that. Thank you.
yeah, and we can actually all be safe and protected and lead with high confidence and courage, because legal is on our side rather than trying to, what does that look like? Again, thank you, Silva. This one was
Yeah.
great. Thank you for being here with us. And
For everyone for attending, that's a plus 15 for everybody.
no,
Because now you know what's going on.
exactly. And thank you, Natalie, for saying that the information and presentation was excellent. The master classes are designed for deep learning, deep understanding, and opening your mind where the gaps are so you can take the actions immediately. Again, Sulva, thank you for spending
Yeah.
time
Thank you.
and
Thank you.
making such a beautiful presentation. I loved legal for the first. Otherwise, those contracts, when I look at it, I don't understand all the time, right? But you made it very easy. And for someone who loves marketing, this one was beautiful. It was beautiful.
Yeah,
Thank you.
thank you. I learned through experience. I experienced the onset of GDPR, I experienced the onset of data protection agreements, and I saw that AI creep even within legal, right? And we have all taken risks and we have all learned from it. But if I can tell you my learnings through experience, I think it would help you in making five mistakes in the future, because we talked about it today. So my whole idea for this is just to create awareness, to give you that toolkit to assess yourself and build a better product and build a better company, and that everybody is successful. We are just rooting for you. We are here to help you. And I'm so proud of Chaitra working with all these entrepreneurs, and I would love to support you as best as I can.
Again, Silva, thank you for being with us.
Yeah,
And
thank you.
everyone, have a great week and more amazing things that are coming along the way. So we will love to see you soon and have a great day. Thank
Yeah,
you.
thank you. Take